Hello everyone and a very warm welcome to all of you. I am Jyotpreet and I welcome you all on the behalf of the team of HitBullsEye for discussing the most important set of judgments and topics that have come up in the month of July 2022. Now let's just quickly go through, what were the major developments that we have seen in this time period by the Supreme Court. Right, so the first and foremost we have Manoj Parihar versus the state of Jammu Kashmir. So basically what has the Supreme Court held in this specific judgment was that if the Supreme Court or the court declares any law, right, if they are declaring any law, then it will as a general rule have a retrospective effect. What does that mean? So please understand, it will have a retrospective effect, and further the judgment has stated that as a general rule it will have a retrospective effect until and unless the court clearly states that it will not have one. That is, until and unless it is stated that okay, so basically let's firstly understand the term retrospective here. ठीक है, रेट्रोस्पेक्टिव का मतलब होता है कि नाउ दैट लॉ और दैट डायरेक्शन इज गोइंग टू हैव एन इफेक्ट फ्रॉम बैकडेटेड. Retrospective, there are basically two kinds of law. One is retrospective and the other is prospective. When I'm talking about retrospective, retrospective का मतलब ये होता है कि वो जो law है it will come into effect from a previous date. That is, आज की date, let us now assume today, if I assume that it is the 1st of January, then it will come into effect before this date also and it will be effective further also. Prospective का मतलब होता है कि वो 1st of January से ही लागू होगा. So that is a prospective. So what has the Supreme Court clearly stated that जब भी अब एक court एक लॉ डिक्लेयर करता है, इट विल एज अ जनरल रूल हैव रेट्रोस्पेक्टिव इफेक्ट. दैट इज, इट इज गोइंग टू हैव अ बैकडेटेड इफेक्ट. However, if the court clearly mentions that no, this law will not have a retrospective effect, then it will have a prospective effect. So general में retrospective मतलब पिछली डेट से पुरानी डेट से आएगा, and until and unless the court states otherwise, the law or the rule will be applicable from the for all the perspectives, all the judgments, all the laws that are there before that. So the Supreme Court had reiterated that the declaration of law made by the court will have retrospective effect if not otherwise stated to do so specifically. Until and unless court ने clearly कहा है कि नहीं, retrospective effect नहीं होगा, then it will come in over here. Right, so this is basically the perspective that was dealt with under the state of Jammu and Kashmir in relation of their appointments through the state public service commissions. That is, it must be made, or the appointments shall be made specifically on the basis of merit and retrospectively. Please understand that. Let's move to the next judgment. The second judgment that we are going to talk about is Malkeet Singh Gill versus the state of Chhattisgarh. Now, we are going to be discussing two perspectives in relation of the running of punishments. When I'm talking about the running of punishments, you must have often come across two words, that is concurrent running or the consecutive running. ठीक है, अब क्या होता है इन अ केस, व्हाट कैन हैपन इज यूजुअली जो ट्रायल चल रहा है उसके अंदर अ पर्सन कैन बी गिवन मल्टीपल पनिशमेंट्स. राइट, उन्होंने एक अलग अलग ऑफेंस किया हो. Now it's not always that a person commits only one offense. There may be a situation जहाँ पे a person committed a series of multiple offenses. जैसे कि a person entered a house, हाउस ब्रेकिंग किया उसने, हाउस ब्रेकिंग के बाद अंदर जाके थेफ्ट कमिट किया, थेफ्ट करते करते फिर थ्रेट केम अपॉन, सो थ्रेट के अंदर द थ्रेट ऑफ लाइफ अपॉन अनदर पर्सन, रॉबरी हो गया, रॉबरी से आगे डेथ कॉज होगी. सो वी हैव सो मेनी चार्जेस दैट आर गोइंग टू कम इनटू इन ऑल ऑफ दिस ट्रांजैक्शन. तो क्या होता है, लेट अस अज्यूम कि 4 ऑफेंसेस थे, उनकी अलग अलग पनिशमेंट्स आई. किसी की आई 2 years, फिर आया जी 4 years, फिर आया 3 years, and then lastly we have 7 years. वी आर ओनली अज्यूमिंग कि ऐसे ऐसे करके अलग अलग ऑफेंसेस की कोर्ट ने डिसाइड किया जी ये पनिशमेंट्स होंगी, राइट। अब इफ वी वर टू रन देम कंसेक्यूटिवली, दैट वुड मीन 2 + 4 + 3 + 7, ये हो जाता है मीनिंग ऑफ consecutive running of punishments. On the other end we have concurrent running, मतलब इसमें से जो सबसे ज्यादा होगा ये मैक्सिमम पीरियड को ही हम कंसिडर करते हैं, इसमें कोई एडिशंस नहीं होने वाली. सो दिस इज concurrent running of your sentences of punishment. अब इसको जो केस है इसके अंदर क्या हुआ है इन दिस रिलेशन, यहाँ पे कहा गया है जो ट्रायल या एपेलेट कोर्ट है they have full discretion or full authority to order sentences to run concurrently. मतलब एक तो है जी, प्लीज अंडरस्टैंड, ट्रायल कोर्ट जहां पे आपका ट्रायल है एंड सेकंड इज जहां पे आपकी अपील है, दैट इज योर एपेलेट कोर्ट. नाउ एपेलेट कोर्ट के पास एज वेल एज ट्रायल कोर्ट के पास, दोनों के पास पूरी पावर है that they can decide whether these punishments should run concurrently or consecutively. It is the discretion of these courts. So the Supreme Court observed that the trial court as well as the appellate court has full discretion. They do not need a revision. They do not need a approval by any other authority to order sentences for 2 or more offences at one trial to run concurrently. So it is now allowed कि वो concurrent running, that is maximum period यहाँ पे क्या आ जाएगा 7 years, whereas in the other situation it would be 16 years अगर हम इसको consecutive running में करें, ठीक है. सो ये पूरी पावर है कोर्ट्स के पास. लेट्स मूव टू द नेक्स्ट जजमेंट. Now next we have State of Madhya Pradesh through Principal Secretary versus SEEMA SHARMA. What is being talked about over here in this case is they are talking about employee rights. Up, let's just quickly go through. Right, an employee cannot claim parity of pay scale with another due to mere similarity of designation or similarity of quantum of work. ठीक है, दो चीजें बोली हैं. बेसिकली यहाँ पे क्वेश्चन क्या आया था, कैन एन एम्प्लॉय, नाउ प्लीज अंडरस्टैंड थ्रू योर directive principle of equal pay for equal work, they came about an act that was known as your Equal Remuneration Act, जिसके अंदर there are given, the act gave some criteria जहाँ पे who all shall be given equal pay when they are working in the same perspectives or in the same work. But the question that came up before the Supreme Court in this judgment was कि क्या or can similarity of designation of the employee or similarity of quantum of work, can these two be the only criterias अगर हमने equal pay देना है इन दो employees को? So the Supreme Court has stated that these are not the only criteria. There have to be more things that have to be looked into. And what are these things that must be looked into? So we see the doctrine of equal pay for equal work could only be invoked when the employees were similarly circumstanced in every way, meaning they have to be in same situation in every way. Merely similarity of designation or quantum of work was not determinative of equality in matter of pay scale. So that is not the only thing that is going to be there. Please understand the court further stated, उन्होंने कुछ और grounds दिए हैं. Court held that all the relevant factors such as mode of recruitment, that is through which way was he recruited, qualifications for the post, meaning क्या क्या requirements थी for this post, the nature of the work that is being performed, and the value of work, that is how what is the role and what is the value of the work, responsibility involved and various other factors. So please remember यहाँ पे question आया क्या यही दो चीजों के basis पे हम equal pay grant करें. The court says these are not the only not the only grounds on which we will now be granting equal pay. There are more grounds, as we can clearly see, have been given by the Supreme Court in this judgment itself. So please remember, only designation and quantum of work are not the only things that will now guarantee equal pay for equal work. Moving ahead. Next we have the CEO Bhilai Steel Plant versus Mahesh Kumar. Right now, basically what comes up in this question is that the person now what came up in question before the Supreme Court in this case was, if a person he is acquiring a seat or he is acquiring an appointment on the basis of a false caste certificate, so basically he is taking a wrong benefit of your reservations over here. Now, can he be allowed to continue that appointment and gain the benefits of that appointment or not? So the Supreme Court has clearly stated that a person who secures appointment on the basis of a false caste certificate cannot, please remember the wording is cannot, be permitted to retain the benefit of the wrongful appointment. So Supreme Court has denied this, and he has said that if a person has acquired the has acquired any job by giving a false certificate of caste and has claimed wrongful benefit of reservation, उसको ये benefit enjoy करने का right नहीं मिलेगा. So Supreme Court bench of Justices Krishan Kaul and Hari Krishna Roy observed that when a person secures appointment on the basis of false caste certificates, he cannot be permitted to retain the benefit of that wrongful appointment, because that is now against the basic rules of caste. अगला आता है State Bank of India and others versus Dr. Vijay Mallya. Now we've all we all are aware of Mr. Vijay Mallya, who was now a liquor baron in India, and he is now regarded as a fugitive who has unpaid debts in the country. Now, what happened was, earlier the court had now stated very clearly under its order, they had ordered Vijay Mallya that he cannot transfer any money from his assets. So he was not allowed to transfer any money. ये एक पिछला order आया था. In violation of this order, now what he did was he transferred about $40 million US dollars to his children's accounts. Right, this activity now already being prohibited by a judgment order. यहाँ पे basically the question that came up was the concept of contempt of court. Now every year we see so many judgments that come up in contempt of court. This is another one जहाँ पे now Vijay Mallya has been fined under the contempt of court, and he has been asked to redeposit that $40 million along with additional fees, so as to, because he has now committed that offense. Question comes up, ये contempt of court है क्या चीज? Now please remember, contempt of court as a general thing means that you are doing something that goes against the authority of the court, right? So you it's now divided into two categories. एक होता है civil contempt, एक होता है criminal contempt. Civil contempt की अगर हम बात करते हैं, जहाँ पे any person shows willful disobedience towards a court order, that is regarded as civil contempt. Civil contempt के लिए accordingly there can be various penalties, punishments through the Contempt of Courts Act. And accordingly, the High Court as well as the Supreme Court can grant a penalty on the basis of the provisions given under the Contempt of Court Act. So, यहाँ पे यही चीज आई है, that is the civil contempt question came up over here. Let's quickly go through the provisions. So, the Supreme Court sentenced fugitive liquor baron Vijay Mallya to 4 months of imprisonment for contempt of court and asked him to deposit 40 million US dollars. Right, this is in violation of the order. Mallya was found guilty in 2017 for transferring USD 40 million to his children in violation of the orders passed in a case filed by the consortium of banks led by the State Bank of India. तो ये पहले एक judgment आई थी 2017 में, जिसको now accordingly he had violated this thing. So therefore court had directed him to deposit 40 million US dollars with 8% interest within 4 weeks with the concerned recovery officer, failing which attachment proceedings will be initiated against his proceedings. So and if he does not deposit this amount, then accordingly attachment of his property will be brought into question. Let's move to the next judgment. Right. So basically next is Bhilai Kumar versus State of Chhattisgarh. Now understand that when a person has been sentenced, किसी को एक सजा हुई है, अगर सजा 1 साल की है, 2 साल की है, 3 साल की है, whatever the amount will be. Now that person can only be kept in jail or he can only be imprisoned for that amount of time, that is total of 3 years if the punishment is 3 years. If that person is kept imprisoned beyond that quantum of his sentence, that is a clear violation of that person's right to life. Article 21 में जो हमारा right to life mentioned है, this is the clear fundamental right that gets violated in this situation. So let's understand what happened in this case. Now basically the court says that detention period beyond release date. So release date, that is the date where that person has completed his sentence, is a violative of article number 21, and Supreme Court granted rupees 7.5 lakh compensation to the convict who was kept in prison in excess of his sentence period. Now this was a case of Chhattisgarh, and the order has now come up against the state of Chhattisgarh. So यहाँ पे now the state must compensate this person for the excess time period that he was put or left in the jail beyond his sentence time period. तो यहाँ पे क्या चीज है, आर्टिकल नंबर 21 की एक और इंटरप्रिटेशन आती है. Let's move ahead. Okay, so next we have Mohammad Irfan versus the state of Karnataka. So basically यहाँ पे क्या बात हो रही है, Supreme Court. Now Supreme Court has upheld the conviction and life sentences of 4 persons for causing the terror attacks at the IIS Institute in Bangalore in December 2005. So what is the critical point over here? यहाँ पे question आया था section 121A of IPC का, and इसके अंदर कोर्ट ने, सुप्रीम कोर्ट ने इस जजमेंट के थ्रू क्या कहा है, the Supreme Court has stated that assassination or bodily injury is not necessary for the offences under section 121A of IPC. Now please remember section 121 basically talks about waging war against India. So anyone who wages, attempts to wage, abets on waging. Now this is section 121. 121A क्या कहता है? Let's understand that, because ये आपका है question in this specific judgment. Section 121A की बात हो रही है, where it's clearly stating that whoever within or without India conspires to commit any of the offences punishable under section 121, that is waging war against India, or conspires to overawe by means of criminal force or show of criminal force the central government or any state government, he shall be punished with imprisonment for life or with imprisonment which may extend to 10 years and shall also be liable to fine. अब ये चीज याद रखनी है कि सेक्शन 121 में बेसिकली 3 चीजों की बात हुई थी. एक्चुअल डूइंग, so the actual commission of the act, the attempt to commission, or the third was abetment. However, criminal conspiracy to commit that act has been given under section 121A. जब criminal conspiracy की बात हो रही है, there is no need, there is no actual proof required कि ये एक bodily injury cause होए या फिर एक assassination actual में attempt करी जाए या होए. Criminal conspiracy, that is the mere coming together of two minds. Now, in furtherance, जैसे ही prove होता है, that person can be charged under section 121A of IPC. Moving ahead. Now, next comes Ansar Mohammed versus State of Rajasthan. What we are talking about in this specific judgment is, can a woman file a charge of rape where there is, a failure of a long-term live-in relationship? Please understand, where a person makes false promises for marriage, that is a different situation. यहाँ पे the person or the man, the male person here, he wanted to get married to this lady. He was making an effort. However, he could not fulfill that promise, and they were together, living together under a live-in relationship. And upon the failure of the same, the woman under this case had now filed a case under rape of IPC. So इसी केस में सुप्रीम कोर्ट ने ये कहा है that just because there is a failure of a relationship, it does not become a ground for the lady or the woman to now file for a rape case against the man, because she was consensually living with that man, and there the question of rape is all based on consent. So इसीलिए वहाँ पे rape का question नहीं arise किया. Let's quickly understand the wordings of the judgment. So the failure of a relationship is no ground. So it is no ground for an FIR for repeated rape when the woman was willingly living with the man for many years. So remarking that where a woman has been willingly staying with a man and has had a relationship with him, and if the relationship is not working out on a later date, the same cannot be a ground for lodging an FIR for the offence of committing a rape repeatedly on the same woman, section 376 2N. तो रेप के प्रोविजंस के ऊपर एक इंटरप्रिटेशन यहाँ पे आई है. Supreme Court on this granted a pre-arrest bail to the same man in this question. So you have to understand that just because a relationship between a man and a woman did not work out, does not mean now that the woman can now take or file a plea of rape or a FIR of rape against the same man under section 376 clause 2. Moving ahead. Now, next comes Narinder Singh versus Divesh Bhutani. Now, in this case, what is the question? What is being talked about is that now over here, please remember earlier also we had all covered in our previous videos and the sessions, we had covered a specific judgment in which the Supreme Court has clearly stated that forests must be protected in case of any conflict between economic interest and development, or environmental protection and economic interest. We must pick up environment, and accordingly, safety zones were also talked about in the previous sessions that we have discussed earlier. Now, basically, what the Supreme Court has given to us is a basic definition of a forest. Why? So that any sort of developments around these areas which have not been sanctioned by the Supreme Court, or which have not been sanctioned by the state government or the central government, इनको मना करा जाए, इनको disallow करा जाए, because forest areas को हम protect कर रहे through the environmental law provisions. Let's quickly understand the wordings. Okay, Supreme Court explains the meaning of forest and holds that non-forest activities cannot be permitted without prior approval from the central government in such areas. So further, the Supreme Court says that prior permission of the central government is required to allow any change of user of forest or deemed forest land. The bench held that the lands covered by the special orders under Section 4 of the Punjab Land Preservation Act 1900 have all the trappings of forest lands within the meanings of Section 2 of the Forest Conservation Act 1980. And accordingly, the Supreme Court said that the state government or the contempt authority cannot permit its use for non-forest activities without the prior approval of the central government. So what is important and what is necessary is कि central government का approval important है. अगर central government का approval नहीं होता है, then such encroachments will be considered as violative of law. Let's move ahead. The next one is X versus the Principal Secretary of Health and Family Welfare Department. So basically, what is being talked about in this question is, can an unmarried woman, can she claim a right to abortion? Now, please remember, in our law, if we talk about our legal system in India, we have one very specific and very important law, that is the Medical Termination of Pregnancy Act. The Medical Termination of Pregnancy Act basically now recognizes the right of abortion for women. The question is, what is the definition of women? Does the woman mean that it can only be a married woman? Does it include an unmarried woman or not? So now please understand, the law clearly through its various amendments has stated that even an unmarried woman can claim a right to abortion legally through the NTP Act. So this is exactly what has been upheld and stated through this judgment as well. That is, denying an unmarried woman right to safe abortion violates her personal autonomy and freedom. So violations have been brought in where an unmarried woman wants to now abort. Denying an unmarried woman the right of safe abortion violates her personal autonomy and freedom. Observe the Supreme Court, while allowing an unmarried woman to seek abortion of her pregnancy of a term of 24 weeks, which arose out of consensual relations. So that is absolutely allowed. Please understand, in India, up to 24 weeks time period is the basic lawful time period till which an abortion can be taken up. So this was basically upheld in this judgment. Right. With this, we come to an end of this session, and these were the most important set of judgments that have come up till now in the month of July. For more such videos, do subscribe to our channel HitBullsEye on YouTube. Thank you.